point is important too. There is no special law or court which deals with archbishops and prime ministers. The same law, administered in the same courts, applies to them as to everyone else. Dicey put his third point as follows. There remains yet a third and a different sense in which the rule of law or the predominance of the legal spirit may be described as a special attribute of English institutions. We may say that the Constitution is pervaded by the rule of law on the ground that the general principles of the Constitution, as for example the right to personal liberty or the right of public meeting, are with us the result of judicial decisions determining the rights of private persons in particular cases brought before the courts, whereas under many foreign constitutions the security, such as it is, given to the rights of individuals results, or appears to result, from the general principles of the Constitution. Dicey's dismissive reference to foreign constitutions would now find few adherents, but he was a man of his time, and was concerned to celebrate, like Tennyson, a land of settled government, a land of just and old renown where freedom slowly broadens down from precedent to precedent. You ask me why. Thus he had no belief in grand declarations of principle, and would, I think, have had very mixed views on the Human Rights Act, 1998, preferring to rely on the slow, incremental process of common law decision-making, judge by judge, case by case. Dicey's ideas continued to influence the thinking of judges for a long time, and perhaps still do. But as time went on, they encountered strong academic criticism. His foreign comparisons were shown to be misleading, and he grossly understated the problems which, when he wrote, faced a British citizen seeking redress from the government. As the debate broadened, differing concepts of the rule of law were put forward until a time came when respected commentators were doubtful whether the expression was meaningful at all. Thus, Professor Raz has commented on the tendency to use the rule of law as a shorthand description of the positive aspects of any given political system. Professor Finnis has described the rule of law as the name commonly given to the state of affairs in which a legal system is legally in good shape. Professor Judith Sklar has suggested that the expression may have become meaningless thanks to ideological abuse and general overuse. It may well have become just another one of those self-congratulatory rhetorical devices that grace the public utterances of Anglo-American politicians. No intellectual effort need therefore be wasted on this bit of ruling class chatter. Thomas Carruthers, in 2003, observed that there is also uncertainty about what the essence of the rule of law actually is. Professor Jeremy Waldron, commenting on the decision of the U.S. Supreme Court in Bush v. Gore, the case which decided who had won the presidential election in 2000 and in which the rule of law had been invoked by both sides, recognized a widespread impression that utterance of those magic words meant little more than "hooray for our side." Professor Brian Tamanaha has described the rule of law as an exceedingly elusive notion, giving rise to a rampant divergence of understandings, and analogous to the notion of the good in the sense that everyone is for it, but have contrasting convictions about what it is. In the light of opinions such as these, it is tempting to throw up one's hands and accept that the rule of law is too uncertain and subjective an expression to be meaningful. But there are three objections to this course. The first is that in cases without number, judges have referred to the rule of law when giving their judgments. Thus, in one case concerned with an effective increase made by the Home Secretary in the term to be served by a young convicted murderer, Lord Steyne, sitting in the House of Lords, said, "Unless there is the clearest provision to the contrary, Parliament must be presumed not to legislate contrary to the rule of law, and the rule of law enforces minimum standards."